Hi. Let's learn about the Fair Debt Collection Practices Act, FDCPA. The Fair Debt Collection Practices Act is a federal law that limits the actions of third-party debt collectors who are attempting to collect debts on behalf of another person or entity. The law restricts the ways that collectors can contact debtors as well as the time of day and number of times that contact can be made. If the FDCPA is violated, the debtor can sue the debt collection company as well as the individual debt collector for damages and attorney fees. The Consumer Financial Protection Bureau's, CFPB's, debt collection rule clarifies the FDCPA's rules about how debt collectors can communicate with debtors. The FDCPA creates a structure within which debt collectors are allowed to work in an attempt to make debt collection a fair and non-aggressive process. The law limits the time of day when collectors may call, the type of language they may use, and how they represent themselves. Essentially, the law makes it illegal for them to threaten or harass you when they are trying to collect a debt. The FDCPA only applies to third-party debt collectors, such as those who work for a debt collection agency. Credit card debt, medical bills, student loans, mortgages, and other kinds of household debt are covered by the law. The Fair Debt Collection Practices Act specifies that debt collectors cannot contact debtors at inconvenient times. If a debtor tells a collector that they want to talk after work at 10 p.m., for instance, the collector is allowed to call then. Without an invitation or agreement, however, the debtor cannot legally call at that time. Debt collectors may also send letters, emails, or text messages to collect a debt. Debt collectors may attempt to reach debtors at their homes or offices. However, if a debtor tells a bill collector, either verbally or in writing, to stop calling their place of employment, the FDCPA says a collector must not call that number again. The CFPB's debt collection rule also limits how many times a debt collector may call. They may not call more than 7 times in a 7-day period. Within 5 days of contacting a debtor, the debt collector must send a written validation notice that includes. Debtors can also stop collectors from calling their home phones, but they must put the request in a letter and send it to the debt collector. If a collector does not have contact information for a debtor, they can call relatives, neighbors, or associates of the debtor to try to find the debtor's phone number, but they cannot reveal any information about the debt, including the fact that they are calling from a debt collection agency. The law makes it illegal for debt collectors to harass debtors in other ways, including threats of bodily harm or arrest. They also cannot lie or use profane or obscene language. A debt collector is not allowed to physically come to your place of employment. The Fair Debt Collection Practices Act considers a physical visit to your workplace publicizing your debt. They may call you at work, but if you tell them to stop, they must comply. Here are 3 key takeaways. 1. The Fair Debt Collection Practices Act, FDCPA, covers when, how, and how often a third-party debt collector can contact a debtor. 2. The FDCPA sets limits on who the debt collector is allowed to contact in addition to the debtor. 3. If a debt collector violates the FDCPA, the debtor can sue them in state or federal court for damages and legal fees within 1 year of the violation. Hope this would help. Thanks for watching.